Hello, and welcome to Trust Me, It's Complicated, the podcast. I'm your host, John Marshall. The show is dedicated to helping you understand the world of trusts and estate planning and planning for the future. My goal is to make these topics less intimidating and more approachable. Whether you're creating your first estate plan, navigating probate, or trying to protect your family's legacy, that's what we're here to discuss. In each episode, I'll break down complex legal concepts into plain English, or as plain as I can make them, share practical insights from real cases, and give you the tools and knowledge you need to make informed decisions about your future and your loved ones. Estate planning isn't just about documents, it's about people, families, and peace of mind that comes from knowing you've planned ahead. So let's dive in, start building clarity, confidence, and security together. Today, we are going to talk about testamentary capacity. And you may have heard that term, but you're like, what does that mean? And what does it have to do with estate planning? And quite simply, it's one of the foundational aspects of estate planning. Testamentary capacity is the mental ability to undertake estate planning. If I walk into someone's office and I say, hey, I want you to write up a will, okay, a good attorney wants to know, is the client who just walked into my office, do they have the mental capacity to execute estate planning documents, to undertake that kind of planning? And that's important because there are people who are irrational, who are not in their right mind, and they may want to execute a document that makes no sense, but it's incumbent upon the attorney not to judge or to say what is right or wrong with regards to how people want to distribute their estate, but to make sure that when doing it, the person is in the right frame of mind. I was meeting with a lady. She had been determined to have, or she had received a diagnosis of dementia. And based upon the time of day, her ability to recall information was, sketchy. Later in the day, it was harder. Earlier in the morning, she was brighter. But her diagnosis was rather recent. And she came in and she said, look, I have this diagnosis. I want to make some changes to my estate plan. And when somebody says I have a diagnosis of dementia, as an attorney, it's not my job to go, sorry, you have dementia. You have a diagnosis. I can't help you. No, we want to look at the person and say, okay, let's talk. Let's have a conversation about you, your assets, your beneficiaries, your heirs, so that we can determine, does this person have testamentary capacity? And we'll start with, well, tell us about you. Tell us about your family. Okay. Who are you? Who are you married? Do you have kids? Who are you close to? Do you have siblings? Tell us these things. Now, it's not just because we're curious, it's because we want to make sure, does the person we are sitting with understand the relationships they have with other people, with their family, with those around them. And that's important because under our laws, if you have a will, you get to pick who inherits. That's called your beneficiaries. But if you don't have an estate plan, the state has written your will for you. It's called the Florida Probate Code, and it defines who your heirs are. So when we use the term heirs, we mean those people who would inherit under the law, under the probate code as written. So if I'm not married, I have no children, my first heir is my parents. And if I don't have parents living, my next heirs are brother and sister. Okay. And we call these relationships levels of consanguinity. And remember, I told you, trust me, it's complicated. Yeah, we're not even going to go down that rabbit hole. So we're going to stick here on the surface. So heirs are who would inherit if you did not have an estate plan. But beneficiaries are the people who inherit if you have an estate plan. So if someone comes in and I'm trying to determine testamentary capacity, I need to understand, who are your heirs? Tell me about them. Tell me about your relationships. Who are your beneficiaries? Who are the people you're wanting to pick? What's the nature of these relationships? Things like that. Um, One of the things that I am fastidious about is when I meet with a client to do that, if someone else has brought them, that person's not allowed to participate in this meeting. And the simple reason for that is we want to avoid that person either one answering for them, which doesn't allow me to assess capacity, but we also want to make sure that that person isn't exercising control or undue influence over the person who I'm meeting with, the actual client. We want to then explore, do they understand the practical effect of executing a will or a trust? In other words, the law says these are the people who are going to inherit if you don't have a will or a trust. Whereas if you pick and execute a will and trust and you pick people, they may be different. Okay. So I may have my parents, because my wife and I, we're married, we have no kids. If my wife dies before me and I own everything, my heirs are my parents who are still living and I live very close to them. Hey, mom, hey, dad. Um, but I can pick. So if I want my nieces to inherit, they're my beneficiaries. Well, I want the client to explain to me, do they understand how a distribution to a beneficiary, how it's different than a distribution to an heir, and what the practical effect a will or a trust has on the distribution of their assets out of their estate. And this is, a conversation that we have. And as an attorney, we need to utilize our understanding of estate laws, understanding of these kind of circumstances to judge whether or not a person has capacity. And the sad reality is there's no real hard and fast rule that says if they can answer this many questions, they have capacity. And if they can't answer this many questions, they don't have capacity. There's nothing like that. We have to ascertain that because we, as attorneys, are then taking on the responsibility of saying, if we're going to do this, we believe they have testamentary capacity. And if someone were to challenge the will or the trust, we are going to be the ones question about, did Mary Sue, did she have testamentary capacity? Did you ask these questions? Did you ascertain that she understood the nature of her assets, her relationship with other people, the effect that her will or a trust would have on those relationships and the distribution of her assets? And I want to be able to walk in if there ever was a challenge to a will or a trust that I drafted to say, absolutely, these are the things that I asked. These are the things that I look for. And in my professional opinion, as an attorney that does this day in and day out, I believe Mary Sue had testamentary capacity. Now, one of the things that there's a big misunderstanding is that, well, somebody has a diagnosis of dementia. Um, Someone's been abusing alcohol or drugs for years, and maybe it still is. Okay, the courts have said old age, physical frailty, sickness, failing memory, vacillating judgment, or vacillating in judgment. You can see I can read sometimes. Do not negate testamentary capacity. They may be factors that come into it, but they themselves do not diminish or remove testamentary capacity. That's where the attorney needs to use their professional guidance, responsibility, knowledge of the circumstance, and ask the right questions and make sure that that's done appropriately. And look, it's sad. Um, I have told people that I'm sorry, I can't do your estate plan. I do not believe you have testamentary capacity. And that's a hard thing to do because there are people who they know they want to do a will. They know they want to make a change or they want to do something. But at the end of the day, they're not able to articulate various factors or issues that we raised when talking about their relationships and the effect of a will or a trust on their estate or even the assets of their estate. And look, I don't like doing that. I hate doing that. I want to help people. But as an attorney, I don't want to then do something that, quite honestly, if they don't have testamentary capacity, is executing something like a will or a trust in their best interest. And we have to say no, that's not in their best interest. Doesn't mean they can't go to another attorney that may have a different take on it than I do, who may believe that they have capacity. But that's a lot of responsibility that that attorney's taking on by second guessing, our analysis over here. And that's why I tell people, don't delay. Go deal with your estate plan now while you have capacity, while there's no question about it, while you're able to answer all these questions, while you're able to address all of this. Because the longer you wait, circumstances and issues will arise. And if you wait too long, you could lose that testamentary capacity, at which point we either can't do any planning or the plan that you have in place that maybe you want to change is now set in stone.